Hi class, today I want to take a few minutes to discuss about some of the cases that you read about today. And so one of them, of course, is Hoyt versus Florida, where Gwendolyn Hoyt was accused of manslaughter for killing her husband. And, you know, her argument was the trial wasn't fair, not because there wasn't females on the trial, though it was an all-male jury, but because women in Florida were not obliged to actually serve on a jury. So men were obliged to do so, but women were not. And that was, the jury service wasn't imposed, seemed to be on its face unconstitutional because it seems that this is something we all have to do, is serve on a jury. If we all have the right to a trial by jury, then obligation of our citizenship is to serve on one. And the Supreme Court said, no, that's not the case. They said that the fact that jury service was not imposed on women in Florida was not unconstitutional. The dissenting judges, though, and dissents are often as important as actual opinions because the dissent puts it into the record as well. And the dissenting judges found it was sexual discrimination. When Ruth Bader Ginsburg then becomes a U.S. Supreme Court judge, one of her major goals is to overturn Hoyt, and it is done in Taylor versus Louisiana. Read the Title VII of the Civil Rights Act of 64. The Civil Rights Act of 64 is erroneous in the fact that people believe the entire act is really applying to gender as well as a category, which it's not. It's about race mainly. But there are parts of it then that do outlaw discrimination in employment on the basis of sex, and Title VII is part of that. Okay, sorry, here we go. The ERA, we've been talking a lot about the Equal Rights Amendment. The ERA, I want to underscore again, has never been ratified. It is still currently, as of this moment, before the courts, or before the legislation. So whether Congress will ratify that, whether it can be ratified, that's a whole nother ball of wax. There are some who believe that it has to go all the way back through again. It's kind of nebulous as to what has to happen. Is it just a matter of can the remaining states ratify or not? Title VII of the Educational Amendment of 1972, this is a big one. Or Title IX, sorry. Title IX is huge. And listen to my radio clip on Title IX because Title IX really expands education for women. That's one of its main things. Today, it's used primarily as a way to continue to protect females in higher education, and especially those who have children. The Frontiero case, though, I want to take a second. Whoops, I have Frontier on this PowerPoint. Frontiero case is important because Frontiero is, so what happens in this case is you have Sharon Frontiero. She is a Air Force officer. She wants to have her, her husband on her medical benefits. And she couldn't. That was against they didn't allow that. And so when the court looks at this, they do something very different. So if we remember back to our Gessert case, at that point, there was a reasonable. And so that's the reasonableness test. That's what the courts use to look at issues of sexual discrimination. And they say if a reasonable man could find a reason why you would discriminate against women, well, then it was okay. And here, this is a pivotal moment in legal history because at this point, the court says, no, we have to give strict scrutiny to those cases that are discriminating, to those laws that discriminate on the basis of sex. We can't just say there's a reasonable reason for it. We have to say, look at them and treat them as a suspect classification. Meritor Savings Bank, here we start to see sexual harassment being discussed. Notice this, now we're in the 80s. And then the Violence Against Women Acts. And so we'll see those throughout the rest of the 90s. And then into, of course, the 21st century, most recently 2013. So still evolving. Have a great day.